The court will now take up the second case on today's docket, Lee versus the County of Volusia.
Morning, Your Honors, and if it may please the Court, Mohammed Jazeel here on behalf of Secretary Lee. I've reserved 5 minutes for rebuttal. At issue before this Court is whether the text and structure of the Florida Constitution requires that litigants satisfy a three-part jurisdictional minimum of standing to sue. And the answer, we believe, is yes. From the territorial Constitution on to our modern Constitution, the Constitution has always included the phrase judicial power. The court is now faced with a choice. Do you interpret that phrase judicial power broadly or narrowly? That was a choice that sister courts have faced in Oregon, Michigan, Texas, Idaho, Vermont, etc. And the issue comes down to how is it that you interpret the phrase judicial power. And our position is that the phrase judicial power should be interpreted narrowly, consistent with the United States Supreme Court's decision in Lujan, the text of Justice.
Go ahead. Well, I mean, this is obviously a super interesting question, but why are we even asking it in this case where you don't take any position on the actual judgment, what the court, finally said in its order doesn't require you to do anything. Your position all along has been you don't care who gets elected to these positions. You're going to, sign off on whoever gets sent to you. I mean, so why... we've got the overlay of the fact that the Declaratory Judgment Act was designed to kind of get around the idea that you had to actually have an injury in the typical sort of private law kind of sense, which I understand there's also an overlay of the judicial power. But why would we use this, of all cases, to get into this kind of huge sort of, cross-substantive thing that you want us to get into?
2 points, Your Honor. Number one, I'd point the court to Judge Makar's dissent, where he points out that in this case, where there has been no election laws are implicated, none of the Secretary's authorities and responsibilities are implicated, she was, quote, dragooned into court. And that can happen again and again, whether because of some
counsel,
action or inaction.
When you say that, it just sounds like to me you're asking for an advisory opinion in this case. And in your briefs, you talk about how courts shouldn't give advisory opinions. Obviously, we've got the constitutional provisions in certain circumstances that allow that, but ordinarily, the judicial power is not the power to give advisory opinions. And I struggle to understand how you're not kind of ensnared on that point yourself, because you are asking us to effectively give an advisory opinion about what should happen in future cases. Nothing that's going to affect anything in the outcome of this case, but what the Secretary will be subjected to in the future. So what am I missing there?
Your Honor, I'd like to address that point in two ways. One, a thought experiment. What happened if the interveners did not participate in this case? What would have happened had they not interjected themselves? Would there have been a default against the Secretary because she took no position on the issues? And that conceptually sort of frames, in my mind, the concern here. We have a case where the defendant was not taking any position on the merits of the matter, but the First District Court of Appeal went ahead and decided the merits. And now we have an opinion which is subjecting the Secretary to actual lawsuits. There's one in the pipeline now over ballot images, which is making its way up to the court. But
it seems like if there are problems going on in other lawsuits, that the answer is to address that in those lawsuits. Not this is over. This has no impact in the specific judgment has no concrete impact on the Secretary, except for the precedential value that it might have in future cases. Isn't that correct?
Yes, Your Honor, and I guess conceptually you could see this as if this case is going to have precedential effect in future matters and this case has become non-justiciable on its way up, should the opinion itself not be vacated for that very reason? I mean, there's a federal analogy to this, the Munsingware Doctrine, right? Whereas the case is making its way up the court system, but it becomes inappropriate for the court to address the merits, the underlying opinion is vacated. So that could be one possible resolution where we don't have to deal with the consequences of the first DCA's opinion, as Judge Makar lays out in his dissent. That's one possible resolution to that matter. In Munsingware itself...
Well, but you're not complaining about being subject to the first DCA's opinion with respect to the issue that you're raising here because you didn't raise it below and they didn't address it, right?
The issue being what
the
precisely, Your Honor?
standing issue. The only issue that you're arguing here, you start off your brief by saying that the circuit court and district court simply chose to bypass the standing inquiry altogether.
Yes, Your Honor.
So you're complaining about an issue and an opinion that wasn't addressed in that opinion, and I would say that they didn't necessarily choose to bypass it. It looks like you didn't raise it.
So, Your Honor, I take that as an argument concerning waiver, as my friend has raised in his papers. And here are a couple of points. If the argument that we're now presenting to the court is that standing is a jurisdictional threshold, it can't be waived. Number two, if you look at the actual record in the case and we look at the motion to dismiss that was filed, the appellate briefs that were filed in this case, we talk about how there's no case in controversy as to the secretary. There's no antagonistic relationship. Yes, we didn't use the word standing, but the way that we presented the argument, both at the circuit court level and at the first DCA, makes clear that what we're saying is there's no antagonistic relationship, there's no case in controversy as to the secretary. Third, Your Honor, I'd like to provide the context for the secretary's arguments. There was one snippet in the complaint that talked about the secretary's powers to countersign commissions once people have been elected. That is what prompted the secretary to make the argument she did at the motion to dismiss stage and in her appellate briefs at the first DCA. The first DCA, sua sponte, however, discussed the secretary's broader election authorities. So under the circumstances, if the point is waiver, Justice Lawson, we would respectfully suggest that A, standing can't be waived, and B, the facts of this case suggest that standing wasn't waived.
Can I ask you about doctrine, though? So it seems like in these cases where you have parties suing government officials trying to get, declarations as to what the law means or whether something's constitutional, it seems like they have this body of law, trying to figure out who's the proper government defendant in cases like that. And it focuses more on the defendant than on kind of the quote unquote injury or whatever the harm to the plaintiff might be. And the other side kind of makes a point that there's, value in sort of keeping those things, even though they're related, kind of keeping them analytically distinct. Do you have a problem with that body of law in the first DCA such that you think that we need to kind of replace it with this injury in fact thing? Or do you think that they just kind of misapplied it in this case? Because it seems like it's a close case as to whether they got that part of it right, but that doesn't necessarily argue, that could be an argument for just kind of saying that the doctrine itself is fine, but they misapplied it, versus you're asking us to make these very broad pronouncements about standing law in Florida in general that have all kinds of applications, that are way beyond what we would need to do to kind of address what happened in this case.
Sure, Your Honor. And I'll take that question and divide it into two parts. One, there's a special injury rule, which is a subset of standing law in Florida. Special injury to sue government entities, and there are exceptions to special injury. That was not discussed in the first DCA, but that is one of the two analytical frameworks Florida courts use for standing. Then the first DCA discussed the Francati case, which is a proper party analysis. So conceptually, we're talking about two concepts here. One is standing, the other is the proper party analysis. And to me, those two concepts are related but distinct. In federal law, it would be analogous to 11th Amendment issues and standing issues. There's overlap. We discuss who is or isn't the proper defendant in a case, but they are distinct. So I'm not asking you to undo the Francati case, but I am asking you.
But isn't that what this is about? I mean, why? It just seems like why aren't you why isn't the first paragraph of your brief saying, this case gives the Supreme Court a great chance to clarify the Francati thing and the proper defendant, because that's really what this is about.
I disagree, Your Honor. I think the proper defendant analysis is, let me back up. I think standing is a condition precedent to the proper defendant analysis. You have to have the jurisdictional minimum, as we point out, of standing for you
But
to
in
then
this
go
case,
to-
but standing, so part of the standing is obviously focused on the plaintiff and whether they've been harmed or whether they have a legitimate problem. Do you have a problem with the county having been the one to kind of raise these? Your problem is that they've raised it against a defendant that doesn't really have a stake in the case, which is obviously kind of puts you into Francati land, right?
Well, Your Honor, it puts us into the redressability prong of the standing test that we're arguing about. The redressability prong.
There's three, aren't there three? It's injury,
causation,
whether it's the
redress-
defendant, and whether it's redressable. So in this case, isn't this the second part that you're worried about?
It'd be the third part. So if there's a declaratory judgment entered against the secretary, what's the declaration saying? The secretary is going to not let the supervisor of elections put someone on the ballot? The secretary doesn't do that in county elections. So redressability is the main focus of our three-part injury test. In Francati and the proper party analysis, as laid out by the first DCA, the focus is, well, who has the statutory duties that are being implicated? Right, so that first prong of Francati's proper party analysis overlaps somewhat with redressability, but I think they are distinct. And I hope I answered the question.
Well, you haven't really answered the question of why. I just don't understand. I understand sort of the academic interest in this, having us write some magisterial thing on standing where we have to compare Florida judicial power to federal, and there's all these contested issues in federal law right now about injury in fact and who can do this. We have this very broad declaratory judgment act law that is clearly kind of trying to sort of, at the time that these things came into effect, there were all these questions as to whether declaratory judgments in general were consistent with the powers that had been under. I just don't understand why you're asking us to do this.
Your Honor, at its core, we're asking you to do this because the opinion subjects us to more and more lawsuits on a daily basis. And that's why we're asking you to do this.
But we could fix that by saying, if it's wrong, and I'm not saying that it is, but just by saying that, these types of duties that were invoked by the first DCA. So the first DCA explicitly rejected this whole idea that just signing the commissions is enough, right?
Yes, Your Honor.
They went into this thing about all, your duties and how it relates. And I can understand how, as a repeat defendant, you might think that that's overbroad. I don't know why you're not asking us, putting aside the whole advisory opinion question. But if we were going to give an advisory opinion on something, it seems like the appropriate thing would be on clarifying for the Secretary of State and your role in the elections laws. Like, is this kind of high-level sort of uniformity thing, is that enough to make you a defendant in every one of these cases? We don't need to reinvent the wheel on standing to answer that question.
So, Your Honor, if I understand your point, you're saying that you can get to where the Secretary is asking you to be by providing greater clarification on the proper party analysis under Francati and cases like it?
Yeah, what's wrong with that?
There's nothing wrong with that. There's absolutely nothing wrong with delineating what is or isn't the proper party analysis. I'm simply saying that there is also another way to get there, and that other way is perhaps cleaner, because the Francati line of cases are still developing on some level. The first DCA is Francati line of cases, writ of prohibition cases, they're in flux. There isn't a clear, or there is a standard. And if you look at the Francati, they have a three-part test. The second two parts are implicated if you don't cross the threshold under the first. The third part of the Francati test overlaps with the first part of the Francati test. So it itself is in flux. But we also have standing law that's in flux in this state. We cited in our briefs 2 circuit court decisions 4 days apart that relied on completely different tests. So there are 2 ways to get to where we're asking the court to get to. That's true.
If the Secretary of State should not be here, who should be?
If the Secretary of State should not be here.
Yeah, who should they have sued instead of the governor was dismissed, right?
Yes, Your Honor.
And you said the Secretary of State also should not be involved in the lawsuit. Who should be on the other side of this?
The supervisor of elections. If someone is an applicant and they're saying that under Volusia County's charter amendments, no election should be had, someone who is applying for one of these appointed positions could sue the supervisor of elections who said that they're holding an election. Or the inverse is true. If someone wants there to be an election and the supervisor is not holding an election, they can sue the supervisor of elections saying, you ought to hold an election. We think that that's constitutionally required. That would be the appropriate case. But here we had folks sue the Secretary of State. And again, just conceptually, if there weren't interveners in the case, there would have been a default because we've taken no position. And so you would have had a constitutional amendment that was passed by the voters and the Secretary of State has no position on the merits, being the nominal defendant. How would that have squared with the exercise of judicial power?
Well, what would the supervisor of elections likely have taken the same position? We take no position?
I don't think they could.
It is what it is. Whatever the law is, that's what it is.
Well, Your Honor, I think respectfully, the supervisor would have been in a different position because the supervisor has a duty under the Florida Election Code to qualify candidates, right? So if there's going to be an election or not going to be an election for a countywide seat, it'd be the supervisor of elections who has an actual task to do. And there could then be some kind of judgment that says, supervisor, thou shalt hold an election and qualify people.
But why would you assume that the court would, in the absence of any kind of adverse presentation, why would you assume that they would go ahead and address the merits anyway?
So, Your Honor, again, if there were no adverse presentation, then the Secretary were the only party to the matter, and the court, as the circuit court in this case concluded.
No, but you don't know. The court has discretion. They could say, look, I'm going to whip out May versus Hawley. I don't need to get into, the federal three-part standing thing. It says that, one of the minimum things to make it judicial is that there's that there's adverseness, that there's a true controversy here, and maybe the court wouldn't have decided the merits.
But that happened here, Your Honor.
Because there was adverseness.
There was adversity here, but May versus Hawley was trotted out. The arguments were made that there's no antagonistic relationship, no controversy, but the merits were addressed because the interveners were there. Interveners under Florida law are subordinate to the original parties.
Well,
right?
these guys weren't. But anyway, I'm sorry. I don't mean I'm not.
Okay, counsel, you're well into your rebuttal time, but I'll give you another 30. I'm going to add another minute because we helped you use it. So you can keep going, but Your
Honor, I will address my friend's arguments. Thank you.
May it please the court. Barry Richard, representing the Florida Association of Court Clerks. I've had the honor of appearing before this court numerous times in my career, but this time what brings me here is truly unique. I have no opponent in this case because the Secretary and my clients have no disagreement as to anything that really matters here. The reason I'm here is a peculiar set of circumstances that occurred in this case. My client's sole interest is in sustaining the judgment below. DCA unanimously affirmed the judgment on the merits, and no one now before this court challenges the judgment on the merits. So I would not be here were it not for the potential ramifications of a dicta disagreement in the District Court of Appeal. The majority of the District Court held that the Secretary was a proper party. Judge Makar agreed that on the merits of the case, but believed that the Secretary was not a proper party. However, he concluded it made no difference because my clients, as interveners, were the real parties in interest and had vigorously argued the case. So the case was appropriately handled and the lower court made an appropriate decision. Here's where the problem occurred. In response to Judge Makar's dissent, the majority opinion says that they disagree with him. They believe that the intervenors were not full parties because the trial court order didn't make them full parties. And then the comment is made that if they were not full parties and the Secretary were not a proper party, there would have been no adversity for purposes of jurisdiction, and that's why I'm here. That's the only thing that concerns me. And my position on this is that, first of all, there is no rule that I can find in the law that says anything about the fact that a case must be dismissed or a judgment vacated because the intervenors, who happen to be the real parties in interest, are the only parties left in the case at the end. I know nothing. I looked, couldn't find anything that said that. The only thing that the case law says about this issue of being a full party is that an intervener that is not a full party cannot introduce any new issues into the case. That's the only thing the case law says. And as a matter of fact, in the case that I cited in the first district, the court pointed out that beyond that, interveners have all of the same rights as any other party to the case. My client never introduced any new issues. The only issues they ever discussed in this case were the ones that were raised in the complaint. Second, this whole issue of the fact that the trial court did not include the magic words as full parties when it granted an intervention that nobody objected to would be a classic case of form over substance, in which we would be saying that all the judicial labor that went into this case was fully and properly argued is going to be thrown out the window. And I don't understand what the public policy purpose would be for taking a position like that. So in short, my only purpose with this court is to urge the court not to reach the conclusion that was suggested, never really held by the District Court of Appeal, was suggested that if the Secretary of State was not a proper party, that the judgment below could not be sustained on jurisdiction. Now, what this also leads us to, that my esteemed colleague and I really have no fight before this court. The Secretary of State has never taken a position on the merits of the judgment below, and my client really doesn't care, in this case at least, whether or not the Secretary of State was a proper party. There is only one thing that counsel said that I do disagree with, which is how we got here, and which, again, I don't know that this court really needs to address, but it's an interesting academic question, which is whether we were really talking about standing. Because my position was that the argument that's being made to this court was never made below and was waived. And counsel's response to that was, well, it's an issue of standing, which is jurisdictional. But as I argued in my brief, they're really not talking about standing. They're talking about the amenability of a defendant to be sued, which is a different issue than standing and is not jurisdictional and can be waived. Counsel gets to this by a winding path in an effort to get this court to adopt a theory that would enable him to indirectly allege that what they argued before was standing. But of course, we know they didn't. Counsel told you today they had no question about the standing of the plaintiff. In any case, Your Honor, I don't want to take up any additional time of the court. That's the only position of my client, and unless the court has any questions, I have nothing further. It's been a pleasure, by the way, to be here in person for the
Mr.
first time in 2 years.
Before you sit down, I know your client doesn't take a position on whether the Secretary of State's a proper party or not, right? But you've been around election law. What's your view? Are they a proper party or not?
I think that they are a proper party. And, Your Honor, what strikes me is the question that you asked, which is a question that's been around for as long as I've been doing this business. If not a proper party, who is? The difficulty that we have is there are cases in which there's a legitimate question as to the validity of a statute, but there is no enforcing authority. And so who do you sue? And we know the lawyers jump through hoops to figure out somebody to sue. And there have been proposals over the years to the legislature that they fix that by telling us who would be a proper party under those circumstances. The Attorney General, the Secretary of State, whoever it may be. When counsel says they could sue the supervisor of elections, in this case, I agree with them, but in some cases, there is not anybody that would be a proper party. I don't know the answer to that, and I don't know that this court has the power to solve it. I wish the legislature would.
Thank you.
Thank you.
Rebuttal.
Your Honor, my friend Mr. Richard's clients filed a motion to intervene below. They did not talk about whether or not the secretary was a proper party or not. However, the tax collectors did talk about whether or not the secretary was a proper party. And the tax collector said on page 101 of the circuit court record that the secretary has no apparent interest in the outcome of this case, which is why the tax collectors asked to be included in the case. And conceptually, getting back to the relief that my friend was talking about, one way to look at why we're here is if standing is a jurisdictional prerequisite that every court must assess before it goes on to the merits, then was there standing at all, ever, in this case, if it was only the interveners who participated in the case and, based on my review of the record, didn't establish through record evidence that they had an injury in fact that was caused and that can be redressed. It's one way to look at whether or not the entire exercise was one advisory opinion. And if it was one just long advisory opinion from the circuit court all the way up to this court, then should any of the orders that were issued stand? And if that's the case, then...
But if you're kind of a stranger, according to your own position, you're really a stranger to all this. This has got nothing to do with you. So why do you care?
Because there are very real consequences that flow from what was said about us. And the fact that we have no ability to correct the record, to take up the issue of whether or not we should have been in the case to begin with, I think is important. And I think that gives us skin in the game. That is the only skin in the game we have. Because again, we took no position on the merits.
But asking it a different way, if we dismiss the case, what's the harm to the secretary?
If you dismiss the case, what's the harm to the secretary?
Yeah,
the harm is the precedential effect of the first DCA's opinion that continues to linger.
So you'd have to raise the issue in whatever case that there is to try to get that first DCA case overturned if you thought in those circumstances that were followed in some way that would try to get it back here to this court. That's
so
what you're
we
saying.
would have to raise the issue in circuit courts that are confused about how to resolve the issue. Then we would have to go to the first DCA, which would be bound by the prior panel rule, by its opinion on proper party analysis. And then we would have to come to this court as elections come and go and mootness arguments are raised anew about an election has happened.
Yeah,
to then see.
we do that a lot around here.
To see clear. Your Honor, my point is this. If we look at the federal universe again by analogy, you have concepts of mootness, you have concepts of waiver, and you have concepts of Article III standing that all reside in the same universe, right? And so we can have discussions about mootness and waiver. We can talk about elections issues, which seemingly are implicated here, but still get to the part of the issue that we're raising. And that's perfectly appropriate in the federal universe when they are looking at the threshold question of standing to sue and whether or not a court properly had jurisdiction from beginning to end. And that's why we're here. We're asking you to assess whether or not there was an appropriate exercise of judicial power from the beginning of the case to the end of the case. Because if our theory is correct and standing as a jurisdictional prerequisite, that needs to be assessed all the way through. With that, I have nothing further to add, and I would ask that you vacate the opinion as to the Secretary. Thank you.
All right. Well, we thank you both for your arguments in this case today. The court will now stand in recess for about 10 minutes before we take up the third case on today's docket.
All rise.